I've just had Justice Short on the line. Sir, thank you very much for your time this afternoon. Let's engage you quickly on this matter. Yesterday, you were there yourself, and I'm just reading through some comments that we're getting from social media. A number of people think that, look, this is the hard truth. We should just deal with it and look at how we can perhaps conduct another research that either could defeat it or support it.
Well, it may be true, it may not be true. I wasn't convinced because, in the first place, I don't know the criteria he used for determining which cases are political cases. And then, secondly, even if the criteria was well-founded, you would have to show me in each case that there are no flaws in the judgment, that there are no defects, that the facts and the law did not justify or justified the conclusion. In other words, the mere fact that, let's say, a particular president has appointed a judge, and that judge gives judgment in favor of the party of that president, it does not follow automatically that the judgment is flawed or biased, unless you can show me that, there is some error in the judgment and the judge has actually manipulated the facts and the law to suit the particular president or the president's party. So unless all those facts are established, in law, it is difficult to draw the conclusion which he has drawn.
If I may come in, sorry, sir, if I may come in at this point with a point that Professor Atuguba makes. He says that mostly this happens in cases where the law is not clear, in cases where discretion had to be exercised. That is where you see a split, because then it means that the law itself doesn't give a clear-cut solution to the particular problem they may be dealing with, so they have to exercise discretion. And that's where you see voting along, if you like, partisan or biased lines.
Well, for me to be convinced, I'll have to see that in that particular case, the law is not clear. And there is room for discretion. And the discretion has been exercised in a way which favors, the president or the president's party. So unless you can demonstrate that to me, I don't see how I'll be convinced, And then I don't know the criteria that is used for determining which cases are political and which are not, But then this whole thing about, you are dealing with cases where the law is not clear. I would have to be satisfied that the law is not clear. I mean, if I looked at the case, I might come to a different conclusion about the law.
Isn't it only natural that judges, the judges who were present while he was going through this information, isn't it only natural that the judges will react the way they reacted because it concerns them, because it bothers them, because it was about them?
I don't think so. I reacted negatively because I'm not a judge. I'm not one of those affected. But I questioned the logic. I asked him whether, he had considered the facts and the law, and he was satisfied that the judge has manipulated the facts and the law before he came to a conclusion. And even if, as you say, that these are cases where the law is not clear and the judge has to use the discretion. Was the discretion properly exercised? It may well be that the discretion was properly exercised. So unless you can show me that in each case the judge has not exercised the discretion properly, then how do you draw the conclusion that the judge has made a finding in favor of the president or his party?
He says that he studied about 100 cases. Now, I'm saying cases and trying to avoid the word political because he just indicated that you're not sure what the criteria for a political case in Professor Atuguba's research is. But he said he studied about 100 cases. This is a good sample, wouldn't you say?
If he can prove that all the 100 cases are political cases. But he wasn't able to to tell the audience the criteria that he was using to select those cases as being political cases. So that is something that he would have to demonstrate, to the satisfaction of readers,
right,
before you will be able to say, yes, these are political cases, and the judge had a discretion, and he exercised the discretion in favor of the president or the president's party. But unless you can surmount those two difficulties, then the conclusion might be questionable.
Okay. Is there any such thing, finally, is there any such thing as absolute objectivity, do you think, really?
Absolute what?
Absolute objectivity. So that, because he basically seems to be making an argument that whichever way you look at it, there is a possibility that your subjective views, your biases as a person will come to bear on the sort of decisions that you make in the long run.
Well, definitely that is true. Your bias can, in some cases, affect your decision, and your ideology, in some cases, may affect your decision. Just like in America, the Supreme Court, people are put on the Supreme Court based on their ideology. So the decisions they give will support the ideology that they proclaim. For example, if it's an abortion case, or if it's homosexual or lesbian case, then that judge's ideology or inclination might support a particular conclusion. But so in those cases, it's quite clear.
Okay.
But unless he can show me each case what the case was about,
okay,
and you can demonstrate that it's a political case, and also that there was room for discretion, and the discretion has not been exercised properly.
Okay.
Then I will not be convinced. So I don't think one should just accept these findings lock, stock, and barrel. One has to scrutinize them and see the process that he has followed in arriving at his conclusion.
Okay. So you're basically saying that a lot more information is needed to be able to either accept or reject this research findings that he's put out there.
Yeah, exactly. That's what I'm saying.
Okay. Let me make this my final question. What are the implications, or what are the potential implications of the perception that some of the judges talked about, that this will, if this is thrown out there, and it has, that there is a potential that you increase a negative perception about the judiciary in the country? What's the potential? What could this possibly do to public confidence? Are there any implications at all at this point?
Of course, it does undermine public confidence in the judiciary. In effect, it is saying that certain judges will decide cases in certain way depending on, who appointed them. So it does undermine public confidence in the judiciary. It undermines the objectivity, But for me, the point I've made also, in fact, this is a point we have made in the IEA when we conducted our winner-takes-all consultation throughout the country. The president should not be appointing judges. The president should not be appointing the IGP. These are non-political positions. And we have advocated in the past that the president should not be, the president should appoint his ministers. He should appoint other people who are going to join him to govern the country. But what particular interest does the president have in appointing the Chief Justice, who is the head of the judiciary? The judiciary is there to dispense justice. What is the interest of the president in determining how justice is administered? You see, so I think that when there is a revival of the constitutional review process, that is one aspect that we are going to look at.
Okay.
So the president has excessive powers of appointment, and these are positions I don't think the president should be involved in appointing. If the findings are correct, then of course it justifies our earlier position that the president should not be involved in appointing, judges, the Chief Justice, the Inspector General of Police, who, when it comes to political cases, is not able to act, especially against, supporters of the administration.
Right. Sir, thank you so much for your time this afternoon. Justice Emil Short is a former commissioner for SRAJ there. In the meantime, we'll be speaking to parliamentarians. Like I indicated, we'll be speaking to both the majority and minority leaders. Let's start from the majority leader, Oseche Mensah-Bonsu.
Appointment of certain officers. Supreme Court. I think I even mentioned it in my own initial submission. I believe we should look at it. And even though elsewhere in the US, typically, justices of the Supreme Court are identified by their political coloration. In ordinary cases, the political views are hidden. The political views are colored, except in matters relating to policy of government. But here, it may be a different ballgame if we pursue that enterprise, which is why I believe, going forward as a nation, if the president should be allowed to do the nomination, the parliament should subject it to the approval of an absolute majority, about 2/3 of members of parliament. That will force the hand of the president to be much more consultative, and not only for the justices, for other institutions. The electoral commissioner, you can't have a president appoint the electoral commissioner, a sole person who does that appointment, and I think it's dangerous. Given what has been happening,
and my view supports that there must be a ceiling of a maximum. I don't think it should exceed 11. I said if the US was 9, we could move up 2 other because of our own historical experiences into 11. I even said at most 30, but at least there must be a ceiling. Because we have also seen instances where justices of the Superior Court were appointed anticipating a particular decision on a matter in this country. That is not right. That is not justice. And the argument then was that you were expanding the panel. Not right to your judgment, but to the politicians. We are quick in going to determine that you have just been appointed to go and support that particular decision, without respect for your conscience and the right that you seek to do.
So, those are the minority and majority leaders there speaking actually today in Gimpa. That happens to be the second day of that conference at which the Professor Atuguba made those revelations.